Well, I think Colby actually requires you to list the rest of the charges out. But if you look at other form,
Right.
it actually says my understanding on Colby is that are supposed to list out all of the other charges.
Here's the problem I see with that. The way the instruction reads right now is if you find the defendant not guilty of murder in the first degree, and you also find her not guilty of murder in the first degree, child under 12, position of trust, tampering. So it would be if you find her guilty of murder in the first degree and you find her not guilty of all these other charges.
Well, this first part is not guilty of basically all the charges, then you answer this question.
Correct. You're right. But my whole thought is they're not required to find her guilty or not guilty of all of them. They could find her not guilty of murder in the first degree after deliberation and still find her guilty of tampering with a deceased human body. And this question, the special interrogatory down here, only applies to murder in the first degree after deliberation.
Right. So each verdict form would have the exact same.
It does.
Here, but then the question actually applies to the charge for that particular verdict form.
Okay. The concern that I had was the concern that I have is that suppose that a jury were to come back and find the defendant not guilty by reason of insanity as to murder in the first degree, both counts, but were to find her guilty of tampering with a deceased human body, then they wouldn't answer this question at all. Yeah.
And I think that's what we just cross that out and
Right.
on each different verdict form. So that
Right.
part B only reflects to the charge on that verdict form.
Right.
I think it is a little cleaner and less confusing.
Because otherwise what you have is they only fill that out if they find her not guilty on all charges. And then they find NGRI as to each charge of each verdict. I suppose out of all the realm of possibilities, they could find that she's not guilty on both counts of murder. But if they find her guilty of tampering with the deceased human body and physical evidence, this instruction tells them nothing about that interrogatory.
Yeah, I totally understand what you're saying. That's the same thoughts that we were having as we were drafting these. The concern is obviously that Colgy actually has it exactly like that. And I'm always reluctant to change what's in Colgy just because of issues.
Right. And I get that.
And I guess that's
Mr.
what
Tellini?
we're having across that. I think it's cleaner and less confusing to the jury. Okay.
As long as the.
Yeah,
Okay.
I would agree to that. I think it's just cleaner
To cross it out.
to cross it out.
Okay.
I think
I'll take
sometimes Colby doesn't anticipate that you'd have these types of things where you have multiple different charges where they could.
Right. Because it's
Not
over a
one.
period of time.
Yes, but yeah, especially because it is.
So, I'll give that to Mr. Young. Can you make those changes? Email them to Mr. Actually, Ms. Gratiano is the one doing the heavy lifting. Can you make those changes? Okay. And send those to Mr. Sproul. And then, so essentially what it will be is when we get there, this part B is just going to say, if you find her not guilty of murder in the first degree, then answer the question. Because the concern that I had was what if we do this, then they're not answering this question at all,
I understand.
which is bad for everybody.
I understand.
So,
It's called because more confusing than it should be.
well, I still blame Judge Gilbert because he's on that committee. So,
Well, I think especially because you don't often have, crimes that occur over.
and that's the other issue.
Period, and that's what
Right.
makes it more confusing and actually more of an issue in
Right.
facing with having.
Right. Okay, so I'm going to give this one with the modification. Are you able to do that, Ms. Gratiano? Do you have that?
Yeah.
She has her computer, we just don't have our computers.
Okay, all right. All right, then I'm going to take a break while Ms. Gratiano does that. I fixed this instruction. Before we do that, though, I want to give some instruction to everybody else that's in the courtroom. And that is, that the plan is that we're going to be, once we get the instructions done, we will be bringing the jury in, around 9 o'clock. As I understand it, and I'm not holding you to this because I told you I wasn't going to impose time limits. I'm just trying to logistically plan. That's all. Do you have an idea as to how long your closing is going to last?
It's hard for me to predict how long mine's gonna last. Mine's the rebuttal close.
No, I'm talking about, I'm mostly concerned about the front end.
I'm trying to keep it to an hour.
Okay. How long? Okay. So it may be. Probably what will happen is the closing arguments are going to start 10-ish. Most likely what will occur is that we get through prosecution, defense, take a lunch break, and then come back for rebuttal, would be my guess. I think it's too long to have the jury all sitting together, missing lunch and everything like that, to do it all in one chunk. So, and it's probably going to take me about 40 minutes or so.
Yeah, it'll take.
Um,
It takes at least that long for it.
Yeah. Yeah, well, it'll probably take me about 40 minutes to get through the instructions. So that's kind of what I'm planning on. If it turns out that we're way ahead, and we may be able to finish in the 12:30 hour, be ready for rebuttal.
My
If you need
preference
to.
would be that we just get them all done.
It's mine too.
I know, yeah.
I just, it's a long time for them to be there. The other thing is, for everybody who's in the courtroom, there's a couple of rules. Number one, no phones. Number two, no phones. The only people that are going to have their phones out are the people in the first 1.5 rows. Those are press people. We know who they are. If you leave the courtroom during a break, you can't save a seat. So take all of your stuff with you if you leave the courtroom, so that when you, if you don't get back in, you have it with you, because somebody else may come in and sit on your, sit where your stuff is, or move your stuff or whatever. So keep that in mind. Council approach, please. Right. In addition, generally, if you leave the courtroom during an argument, you're not going to be allowed back in. So the only time that you go out and come back in is during a break. I know that this is a difficult case for everybody. Jury's working hard. Lawyers have worked hard. You got decorum orders back there about the conduct that I expect. If you think that there's going to be an emotional reaction, step outside. We don't want anybody to be influenced by an improper reaction from the gallery. So we'll leave it at that. So she's working on the verdict forms. I'll take care of this instruction. I'm going to number it. I need to see. Oh, I've got them right here. And I'm going to number this an A instruction, since we've already got the other ones numbered.
Yep.
In that way, as opposed to putting it at the end. Okay.
It's okay.
And then you can just shuffle it in on the other ones. Yeah, that'll work. Right. Are they stapled?
No. You
Is
were
it-
beginning of the end of the stack?
I was thinking, oh, I guess you would have to take a look here. Well, I was actually going to put it up here at like number 10A or something like that, but you'd have to go through all the stacks.
Okay, I mean.
You can do that?
Yeah.
Okay. All right. Okay. All right. So court will be in recess, and when we come back and bring the jury in, rest. Yes?
Yes, sir.
No rebuttal?
That's right.
Okay, and then I will tell the jury what they can expect and how it's going to go forward. Once I read the instructions, we'll take that 15-minute break or so, and then we'll go into arguments. We'll see where we are. I mean, if Mr. Young doesn't take as much time or Mr. Tellini doesn't, it may be that we get it done. It's not a hard and fast noon, but I sure don't want to put them in at like 1 or 1:30 and.
Yeah, and as far as if we can get them all done before we break for lunch, there will be a natural break anyway between Mr. Tellini
Right.
and then me doing my rebuttal close. I'm gonna have to rearrange a little bit here anyway.
I'm glad you brought that up. Can we turn that camera on? We rearranged the camera, and you can see, so you can see where you can be seen in the courtroom if you want to do that and take a look at the camera. My suggestion, however, would be if you're going to use this easel, that you unbury it before we start. So it'll be a little, as opposed to trying to move all that stuff afterwards. So, okay. All right. Court will be in recess then. Thank you.
All right.
Good morning, everybody. Beth said, burn. Yes. Still, are you in a lot of pain? Dental surgery is no joke. All right, today is the day on 2 counts because we hopefully are going to have justice for Gannon and it's wedding day. So today's going to be a little unusual because the stream is just going to go straight through. So when there's like dead air, well, it's because I'm not home. I'm going to be leaving out in a little bit to get wedding stuff done. And so if you could just, when people come in and say, what's going on? There's no sound. There's nothing on the screen. Just remind them that I'm not home. But if something goes wrong with the stream, then I'll just have to take care of it when I get back home. So that being said, thanks for hanging there with me. Tanya said, do you think it is possible for Lena to do the impact statement? You know, I'm really bummed out. Well, because I'm selfish that we didn't get to hear Lena's testimony, but they probably said, let's spare. We have enough. You know, we have, oh my gosh, we have Mount Vesuvius of evidence. We have tons. We have tons of evidence. And, you know, all ado about nothing, or how do they say it? Much ado about nothing. I was really worried about Dr. Lewis. And whoa, if she didn't poo the bed, didn't get there on time, brought Bubby in the yellow shirt that was token up in the stairwell, basically lied on the stand. I'm really surprised that the defense didn't call for a mistrial. Because that's their witness. That was, I mean, every egg they had was in that basket, and that basket broke. Those eggs went all over the place. And she's flipped so many juries. I thought, woo. And she still could. There could be a head petter on that jury that holds all this up. I don't know. I just hope that when they go through their deliberations, they reflect back to those autopsy photos. And that was horrific to see. I hope they reflect back to that. It's going to be really interesting if they want any testimony reread to them. I wonder what it would be. Or they might just go back there and say, nah. She Googled that she hates her stepson. She Googled she wanted to find a man without kids. She toted him around in a suitcase for 8 days. And I know a lot of people still say that she couldn't have thrown him, over the railing of that bridge. It was actually a really interesting comment. It was pointed out to me. In that van, I mean, they're higher up off the ground. Well, she still would have had to have taken it out and putting it there. Either way, Letecia's got some crazy strength going on. Okay. She's got some crazy strength going on. And when you've got that much anxiety, hatred, resentment, you get strong. Wiz said, now if Dr. Lewis writes a book about this, it's going to be full of lies. And I don't know if you guys saw in the Crime Lines and Lies Facebook group, I put a letter up that Letecia wrote where she's complaining about constitutional rights because she's Jewish now and she's not getting her warm kosher food. See, she doesn't want those cold bologna sandwiches and half an orange. She wants warm kosher food. She's even mentioning all these different deputies and how one keeps refusing her warm kosher food. Gotta be kidding me. Yeah. Party of Five says, well, Gannon's father could maybe sue her then. I just can't believe that nothing was done about that. I mean, all of our faces collectively just fell off. And we were like, that chick just lied. Snazzy said she started a federal lawsuit against the prison. Yep. Oh, this isn't the last of Letecia. See, Letecia is going to be stewing in her own juices till the day she meets her maker, and we know who made her. It's got a pitchfork in the picture. So she's going to be a thorn in their side. Carol says, well, I'm Hispanic today. Happy Cinco de Mayo. What's everybody doing for Cinco de Mayo? Tacos, guacamole, fajita, margaritas. You name it, we got it. Wiz said she's Jewish? Nah. According to her. According to her. It's nuts. It truly is. All right, so I'm just going to let this go. It'll be back in about 10 minutes because I have to run out the door. Juicy Tequila Bobo's doing enchiladas and margaritas. That sounds like breakfast to me. Peas is having pizza. Peas is having pizza. All right, guys, if anybody comes in and they ask what's going on, why nothing's on the screen or anything like that, just give them a friendly reminder. We're just going to keep chat going. And when they come back, you'll just hear it. So I will see you guys back in a couple of hours, but the stream's going to keep going.
All right, court will call 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury is not present in the courtroom. Is there anything we need to take up outside the presence of the jury at this point in time? Prosecution?
No, Your Honor.
Defense? Let's go ahead and bring the jury in. So we'll just take them over there. And I tell them and they can just pass them down. Cameras. Oh. All rise for the jury, please. Thank you. You may all be seated. Court will recall 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. Good morning, ladies and gentlemen. We're going to start today like we have every other day. Has anything occurred since we were last together that causes any of you to believe you could not continue to serve as a fair and impartial juror in this case? If so, please raise your hand. No response. All right, when we took our break on Wednesday, we were in the midst of the defendant's case. So that's where we will resume. Mr. Tellini, call your next witness, please. Ladies and gentlemen, what that means is the defense has presented all of the evidence which it intends to present for you to consider the issues in this case. I want to remind you that the defense does not have any burden of proof at any point in these proceedings. However, because the defense did present evidence, the prosecution also has an opportunity to present rebuttal evidence if it chooses to do so, to rebut any of the evidence that was presented by the defense. With that, prosecution, do you have any rebuttal evidence? Ladies and gentlemen, what that means is that all of the evidence which you may properly consider to decide the issues in this case has been presented. Here's what we're going to do going forward. Mr. Combs has some instructions for you. He's going to hand those out. So if all of you would take one and pass it down. All right, the law in the state of Colorado requires that I read these instructions to you, even though you have them with you to take back into court. In addition, because you each have your own individual copy, you can write on your copy any notes that you want to have, just like you would any other notes. Those are not discoverable. Once the case is done, again, those are destroyed. The original jury instructions that I'll give you at the end, those are the ones that need to be filled out. In addition, you'll also see that your instructions start with 9A. That's because we had an addition. So if you hold on to 9A, it's going to go right after instruction 9. Just hold on to it. We'll get there, I promise you. Okay. What we'll do is I will read these instructions, then we'll take about a 15-minute recess or so. Then we're going to come back. Then the prosecution has an opportunity to give you a closing argument. After that, the defense has an opportunity to give a closing argument. After that, then the prosecution has an opportunity to give rebuttal. It's much like rebuttal evidence. They get to comment on anything that the defense had to comment on in their closing argument. So that's the process. I want to tell you, we work almost always on a closing argument, from my perspective, a little bit on the fly because I've not placed time limitations on the attorneys. However, I'm not going to have you guys sitting there for a 4-hour block of time either. So it may be that we do the prosecution closing, the defense closing, and take a break, a lunch break, and then do rebuttal. The other thing is that since we are here for closing, that means that this case has been concluded. That means that you will be here all day. Normally you have gone out to lunch, those sorts of things. That won't be happening today. We're going to order lunch in for you. When we take our break, we're going to have somebody come down and they'll tell you about the lunch process and stuff like that. But we're going to have you here today. And once we discharge you or once we send you back for deliberations, you'll need to stay together for the deliberation period. Members of the jury, the evidence in this case has been completed. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your verdict. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few things to keep in mind when you are discussing this case in the jury room. Until you have returned a verdict, you must not do any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or other electronic means. You must not communicate in any way with anyone else about this case or this kind of case until you have returned a verdict in court. This includes your family and friends. If you have a cell phone or other electronic device, you must keep it turned off during the jury deliberations. Actually, what happens is we collect all of those. You get them back at the end, and sometimes you even get back your own. But we collect them all at the end. We collect them all and we hold on to them during deliberations. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. During this trial, you received all of the evidence that you may properly consider in deciding the issues in the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching your decision. You should not allow bias or any kind of prejudice based upon gender to influence your decision. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant is guilty, it will be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. At times during the trial, attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. Finally, you should consider all the evidence in light of your experience in life. The defendant is charged with committing the crimes of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with the deceased human body, and tampering with physical evidence in El Paso County, Colorado on or about January 27, 2020. The defendant has pled not guilty by reason of insanity. The charges against the defendant are not evidence. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove that the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element of a crime has been proven beyond a reasonable doubt, you should find the defendant guilty of that crime. If you find from the evidence that the prosecution has failed to prove any one or more of the elements of a crime beyond a reasonable doubt, you should find the defendant not guilty of that crime. The number of witnesses testifying for or against a certain fact does not, by itself, prove or disprove that fact. You are the sole judges of the credibility of each witness and the weight to be given the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. A witness qualified as an expert by education, training, or experience may state opinions. You are not bound by the testimony of witnesses who testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight you give the testimony is entirely your decision. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. The court has taken judicial notice of a certain fact. You may or may not accept that fact as true. It is entirely your decision to determine what weight, if any, shall be given to the evidence. And this is where the 9A goes. In response to the COVID-19 pandemic, the El Paso County Jail was accepting WebEx meetings on March 20 of 2020. The defendant's attorney had a WebEx meeting with the defendant on that date around noon. Later that day, Dr. Moore had a conversation with the defendant about Gannon being found in Florida. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on firsthand observation of the fact in question. For example, a witness's testimony that she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. One other caveat to this instruction is that that's That takes time because I have to reconvene the court, have to bring the lawyers in. We have to discuss the question, what the possible response is. So it's not as quick as the questions that we have when you're asking witnesses. During this trial, you were permitted to submit written questions to witnesses. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror is not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision whether or not to allow a question is based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that are submitted by yourself or your fellow jurors. In making your decision, you must consider all of the evidence that has been presented. In this case, a separate offense is charged against the defendant in each count of the information. Each count charges a separate and distinct offense, and the evidence in the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find the defendant guilty or not guilty of one of the offenses charged should not control your verdict as to any other offense charged against the defendant. The defendant may be found guilty or not guilty of any one or all of the offenses charged. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. A voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant has the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. The term after deliberation means not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts intentionally or with intent when her conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by statute defining an offense when she is aware that her conduct is of such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of her conduct when she is aware that her conduct is practically certain to cause the result. These next instructions have to deal with the elements that must be proven for the charges. And it makes more sense once you actually have all of the instructions because it references in instruction 21. The elements of the crime of murder in the first degree after deliberation are that the defendant in the state of Colorado, at or about the date and place charged, after deliberation and with intent to cause the death of a person other than herself, caused the death of that person or of another person, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree after deliberation. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree after deliberation. The elements of the crime of murder in the first degree, child under 12, position of trust, are that the defendant in the state of Colorado, at or about the date and place charged, knowingly caused the death of a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the child, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree, child under 12, position of trust. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree, child under 12, position of trust. The elements of the crime of tampering with a deceased human body are that the defendant in the state of Colorado, at or about the date and place charged, believed that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with intent to impair its or their appearance or availability in the official proceedings, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of tampering with a deceased human body. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of tampering with a deceased human body. The elements of the crime of tampering with physical evidence are that the defendant in the state of Colorado, at or about the date and place charged, believed that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, destroyed, mutilated, concealed, removed, or altered physical evidence with intent to impair its verity or availability in the pending or prospective official proceeding, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of tampering with physical evidence. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of tampering with physical evidence. In this case, certain words or phrases have a particular meaning. The following are the definitions of those words and phrases. Accordingly, you are to use the following definitions where those words and phrases appear in the instructions and define crimes, defenses, special rules, and verdict questions. Cause means that act or failure to act which in natural and probable sequence produced the claimed injury. It is a cause without which the claimed injury would not have been incurred. Homicide means the killing of a person by another. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency, or official authorized to hear evidence under oath, including any magistrate, hearing examiner, commissioner, notary, or other person taking testimony or deposition in any such proceedings. Person, when referring to the victim of a homicide, means a human being who had been born and was alive at the time of the homicidal act. Physical evidence includes any article, object, document, record, or other thing of physical substance. Physical evidence does not include a human body, part of a human body, or human remains. One in a position of trust includes, but is not limited to, any person who is a parent or acting in the place of a parent and charged with any of a parent's rights, duties, or responsibilities concerning a child, including a guardian or someone otherwise responsible for the general supervision of a child's welfare, or a person who is charged with any duty or responsibility for the health, education, welfare, or supervision of a child, including foster care, child care, family care, or institutional care, either independently or through another, no matter how brief, at the time of the unlawful act. The evidence in this case has raised the defense of insanity as a defense to the crimes of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with the deceased human body, and tampering with physical evidence. The defendant was insane at the time of the commission of the acts if she was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or she suffered from a condition of mind caused by mental disease or defect that prevented her from forming a culpable mental state that is an essential element of a crime charged. But care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. In addition, diseased or defective in mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Similarly, mental disease or defect means only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality, and that are not attributable to the voluntary ingestion of alcohol or any other psychoactive substance. Mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. The law presumes everyone to be sane. However, after some evidence of insanity is introduced, the burden of proof is upon the people to prove to the satisfaction of the jury, beyond a reasonable doubt, that the defendant was sane at the time of the commission of the crimes charged. In order to meet this burden of proof, the prosecution must disprove, beyond a reasonable doubt, both of the above-numbered conditions. After considering all of the evidence, if you decide that the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove that the defendant was sane at the time of the commission of the acts, which is an essential element of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence. In that event, you must find the defendant not guilty and have the foreperson sign the designated section of Part A of the verdict form to indicate your verdicts. After considering all the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved the defendant was not insane at the time of the commission of the acts. In that event, your verdicts concerning the charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence must depend upon your determination whether the prosecution has met its burden of proof with respect to the remaining elements of this offense. Instruction 22. Concerning the affirmative defense of insanity, certain words or phrases have a particular meaning. Diseased or defective mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Mental disease or defect means only those severely abnormal mental conditions which grossly and demonstrably impair a person's perception or understanding of reality, and which are not attributable to the voluntary ingestion of alcohol or any other psychopathic substance, except that it does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Moral obliquity refers to an act committed by a person who is capable of distinguishing moral right from moral wrong, but nevertheless acts out a perverse and culpable rejection of prevailing moral standards. Moral obliquity does not include an act committed by a person in a state of mental illness that renders the person incapable of distinguishing right from wrong with respect to the act. Incapable of distinguishing right from wrong refers to cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard or morality, even though the person may be aware that the conduct in question is criminal. The phrase incapable of distinguishing right from wrong does not refer to a purely personal and subjective standard of morality. If you find that the defendant, and this question will make more sense once you see the verdict forms. If you find the defendant guilty of one or more of the following charges of murder in the first degree after deliberation, murder in the first degree child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should disregard the remainder of this instruction and sign Section A of the verdict form for that charge to indicate your verdict of guilty. If, however, I think that's a typo. I think that's supposed to be B. We'll get to it in just a moment. If, however, you find the defendant not guilty of one or more of the following charges of murder in the first degree, murder in the first degree after deliberation, murder in the first degree child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should sign Section A of the verdict form to indicate your verdict of not guilty, and you should also answer the following verdict question in Section B of the verdict form. Did you find the defendant not guilty solely based on the defense of insanity? Answer yes or no. The court reminds you that the prosecution has the burden to prove beyond a reasonable doubt each element of the crime charged, including that the defendant was not insane at the time of the commission of the act. If you decide that the only element of the crime charge that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act, you should mark yes in the appropriate place in Section B of the verdict form and have the foreperson sign the designated form in that section of the verdict form. If you decide that the prosecution has failed to prove any other element beyond a reasonable doubt, you should mark no in the appropriate place in Section B of the verdict form and have the foreperson sign the designated line in that section of the verdict form. In any trial or hearing in which the mental condition of the defendant is at issue, witnesses not specially trained in psychiatry or psychology may testify as to their observation of the defendant's actions and conduct, and as to conversations which they have had with her bearing upon her mental condition, and they shall be permitted to give their opinions or conclusions concerning the mental condition of the defendant. This is an information instruction and must have no persuasive bearing on the verdicts you arrive at under the evidence. If a defendant is found not guilty by reason of insanity, it is the court's duty to commit the defendant to the Department of Human Services until such time as the court determines that the defendant no longer requires hospitalization because she no longer suffers from a mental disease or defect which is likely to cause her to be dangerous to herself, to others, or to the community in the reasonably foreseeable future. If a defendant is found not guilty by reason of insanity, she will never again be tried on the merits of the criminal charges filed against her. The question of the defendant's sanity or insanity has reference to her mental condition at the time of the alleged acts, the condition of the defendant's mind previous to the act charged, and since that time, may be considered only to aid you in determining her sanity or insanity at the time of the acts charged. In a few moments, the bailiff will escort you to the jury room, where you will select one of your members to be the foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form and verdict question form that you may agree on, according to the rules that I am about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. This requirement applies to any determinations that you make in response to verdict questions which you conclude should be answered. Only one verdict shall be returned signed for each count. The verdict forms, verdict question forms, and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, and if required by your verdicts, answering any verdict questions, you will inform the bailiff, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 4 verdict forms. You will also be provided with 4 verdict question forms with directions that explain under what circumstances you should complete those forms. When you have unanimously agreed upon your verdicts, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict form as I have stated. Similarly, if you conclude the verdict question should be answered, you will select the option on each verdict question form which reflects your unanimous decision, and the foreperson will sign each verdict question form as I have stated. I will now read to you the verdict and the verdict question forms. You must not draw any inferences based on the order in which I read them. The verdict and verdict question forms you will receive read as follows. Jury verdict count number 1, charge of murder in the first degree after deliberation. Part A, section Roman numeral 1. We, the jury, find the defendant, Letecia Stauch, not guilty of count number 1, murder in the first degree after deliberation. Part A, section Roman numeral 2. We, the jury, find the defendant, Letecia Stauch, guilty of count number 1, murder in the first degree after deliberation. If you fill out Part A, Roman numeral 1, you are finding the defendant not guilty, and you are finding the issues in favor of the defendant. If you do that, you need to fill out Part B, which asks you the question, if you find the defendant not guilty of murder in the first degree, you should answer the following question. However, if you find the defendant guilty of murder in the first degree, you should leave this section blank. As to the charge of murder in the first degree after deliberation, did you find the defendant not guilty solely based on the defense of insanity? So with respect to each verdict form, you have 3 options. It can be a straight not guilty, it can be guilty, it can be not guilty by reason of insanity. So if you were to find the defendant just straight not guilty, the prosecution had not presented enough evidence to establish beyond a reasonable doubt that charge against the defendant, you would fill it not guilty and be done. If you were to find the defendant or that the prosecution had presented sufficient evidence to prove beyond a reasonable doubt that she was guilty, you could fill it out as guilty. If you find her to be not guilty because she was insane at the time, you need to answer not guilty and answer this question on the back. Verdict form number 2, charge of murder in the first degree, child under 12, position of trust. Section Roman numeral 1. We, the jury, find the defendant, Letecia Stauch, not guilty of count number 2, murder in the first degree, child under 12, position of trust. Section Roman numeral 2. We, the jury, find the defendant, Letecia Stauch, guilty of count number 2, murder in the first degree, child under 12, position of trust. Again, only if you find her not guilty should you consider the question on Part B. As to the charge of murder in the first degree, child under 12, position of trust, did you find the defendant not guilty solely based on the defense of insanity? Verdict form or count number 3. We, the jury, Part A, Roman numeral 1, we, the jury, find the defendant, Letecia Stauch, not guilty of count number 3, tampering with a deceased human body. Roman numeral 2, we, the jury, find the defendant, Letecia Stauch, guilty of count number 3, tampering with a deceased human body. And the same question on the back under Part B. Jury verdict form count number 4, charge of tampering with physical evidence. We, the jury, find the defendant, Letecia Stauch, not guilty of count number 4, tampering with physical evidence, or Roman numeral 2. We, the jury, find the defendant, Letecia Stauch, guilty of count number 4, tampering with physical evidence, and the same question on Part B. So let me go back for a moment, double check this. Section A. All right, let me call your attention back because I may have introduced some confusion. If you look back at instruction 23, and I said I thought this might be a typographical error, it is not. That is an accurate statement. If you find the defendant guilty of one or more of the following charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should disregard the remainder of this instruction and sign Section A of the verdict form that for that charge to indicate your verdict of guilty. That's an accurate statement. What I was thinking about is that it also implicated the insanity provision. But under Section A of each verdict form, you're determining whether she's not guilty or whether she's guilty. So instruction 23 is accurate the way that it was stated and the way that it was read to you. I just didn't want to be there to be any confusion about that, since I may have introduced some. So what we're going to do is take about a 15-minute recess. So if I can have everyone back in the jury room at, say, 5 after 10, we should be able to start on time. Again, even though you've gotten the instructions, still can't start deliberating yet. You have to wait. So don't talk to each other about it. Don't talk to anyone else about it. Don't do your own independent research about any aspect of the case. We'll see you at 10 after 5 when we come back. My hope is that we will probably go until noon. We might go a little bit longer. So, because it would be better to have all of the arguments together. But again, as I said, I don't want you guys to be sitting there for a really long time either. So I'm just going to have to work that out on the fly. So with that, I'll rise for the jury, please. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Set up however you want to set up, and just be ready to go when we get back. What I have told both sides is that my intent at this point in time is just to leave the TV on. I suppose there might be a need to switch back and forth between sources. Pardon?
That would just be on your end, though, wouldn't it?
Right. Yeah. So you.
From there.
Oh, so
And
it'd be the same
okay.
plug then.
Okay.
Yeah, so you just need to tell me what the feed is from, but at this point in time, all of the evidence has been admitted. So I intend to, whatever is up there is going to stay up there until something else gets put up there.
Okay.
So any of this stuff that you want out, you need to move out. This is a suggestion. It is not a firm and direct rule, because I don't want to interfere too much with what the attorneys intend to do during closing arguments. I think probably the poster boards are going to be best right there on that corner of the court reporter's table. So if you want to put something up there or hold them up there or prop them up on the table, that's fine. But if you want to do it over there or on the witness stand, I don't care. So I just wanted to let you know. With that, court will be in recess then.
All rise.
All right, court will call 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury's not present. We okay? Okay. Jury's not present in the courtroom. Is there anything we need to take up outside the presence of the jury at this point in time? Prosecution?
No, Your Honor, thank you.
And you're good to go?
Yes,
Is your feed going to be prosecution table?
yes.
Okay. Defense, are you ready to go? And you're going to use his same feed?
I'm gonna use the,
Podium? Okay. All right. All right. Let's go ahead and bring the jury in. It's just over the line. That's better. And if you're going to use the TVs, it's up to you as to whether you turn the perimeter lights on or off. All rise for the jury, please. Thank you. You may all be seated. Court will recall 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. At this point in time, we will start with the prosecution's closing argument. Prosecution?
Thanks, Judge. Morning. Been on trial. You guys have sat through a lot of evidence, and you're gonna have to sift through that evidence and sift through the instructions, kind of what we talked about when we're selecting you, and apply the facts of this case to the law that you now have been given. Before I start my closing, I want to just say thank you for that. You guys have been very attentive. I can see that every day. You've asked some very good questions that I'm actually going to use in my closing argument as I go forward here. One of the things about a homicide case that is true and to form in pretty much every homicide case I've done in my career is the case kind of evolves to talk about the defendant. We spend a lot of time talking about the defendant. And then when you add that the defense is insanity, you even spend more time talking about the defendant. I want to come back to Gannon in a little bit. Gannon's been in a box back here for the whole trial. This is what the trial should be about. And I'm not doing this to get sympathy from you. I'm doing this to tell you that what Gannon had to tell you in this trial through the autopsy, all you need to know. And when the defendant did what she did to him, saying at the time she did it, not only do we know how he was killed and the effort and determination it took to kill him, we also know that his body was found in Florida. Body wasn't found in Florida. Do you think we'd be talking about insanity in this trial? It's a pure fact of divine intervention that Macon Ponder happened to be searching that bridge when he did. Remember, he said he searched that bridge every 2 years. Just so happened on March 17th, 2020, out there searching that bridge and he saw that suitcase. Dr. Lewis says it was crazy to drive a suitcase across the country and dump it over a bridge in Florida. Was it really? Think about the divine intervention of Gannon's body even being found to get here to where we're at right now. And the effort and determination that she took to hide his body. We're going to talk about that quite a bit more as I go through my closing. What I'd like to do now is talk about the autopsy and his injuries. I'm not going to show you any pictures. I'm going to tell you that right up front. I'm going to use the diagram. I wonder if we can have the TVs turned on. I can start with that to describe his injuries, because his injuries are relevant. They're not only relevant to the crimes that she's charged with, the murder counts, but they're relevant to what her state of mind was when she committed those crimes. And so what we have up on the board now is People's Exhibit 144. You heard Dr. Ignacio testify. We showed you pictures of each and every injury that Gannon had to his body. This first diagram in People's Exhibit 144 kind of depicts the stab wounds. It also depicts the gunshot wound to his left chin area. Now, at least the group that I talked to in jury selection, we talked about every day of your life, you were training to be jurors. That means you're using your common sense to make decisions, just like you're going to have to today when you go back to the deliberation room. Just by looking at these injuries, what does your common sense tell you? Without Dr. Ignacio's testimony, Gannon was defending himself. He was fighting off, despite having hydrocodone in his system. Made him lethargic. He somehow was able to fight her off. The injuries to his fingers, the injuries to his arms. 18 times. 18 times she took a knife. Stabbed him. The locations of the stab wounds. What does that tell you? Use your common sense. It's not psychotic. It's strategic. The stab wounds are to the chest. As Gannon's fighting, the stab wounds are to his back. But it's not just stab wounds. You know that. He has to use judgment and reflection to get another weapon. What that weapon was, who knows? But she got a weapon and hit him in the skull 4 separate times. Go to the next diagram. I forgot to mention the strategic stab wound to his neck just underneath his ear, which we see in People's Exhibit 145. The diagram doesn't do justice to the skull fracture that she caused him. And I'm not going to show you pictures, but I think, remember those pictures? Completely obliterated his skull. The amount of force it takes to do that, judgment, reflection. The next exhibit shows the injuries that he had to the top of his head. 4 separate strikes to his head. Wasn't good enough. Wasn't good enough for her. So, judgment, reflection, she goes and gets a handgun. She fires that handgun 3 times. I don't know how those bullets stay in the pillow. We can rack our brain for ages. I don't know how those bullets stayed in that pillow. I don't know that we'll ever know how those bullets stayed in that pillow. What matters is the bullet that went into Gannon. That bullet matched the gun really she used that was still in the house. He attributed to Quincy Brown using, or Eduardo using, or whatever story of the day it was. Judgment, reflection, location of gunshot wound. Talk about making ponder a little bit. Because as He drives to Florida. She checks in at about 12:22 in the morning, just after midnight, Candlewood Suites, Pensacola, Florida. Why do they drive all the way from Decatur in one night to get to Florida? Why does she want to get rid of Gannon's body in Florida? Gulf of Mexico. You drive this bridge at night, as Macon Ponder testified to, there's no lights on it. We know that sometime between, well, probably between 4 in the morning to 5 in the morning, she's out there. Look at the location where the body was found with the red arrow on People's Exhibit 63. More importantly, look at the space that she has to park this vehicle. I don't know where the pointer is, but you
Right
see.
behind you. It's right there on the window.
Okay, thanks. You can see the shoulder here, and there's plenty of room. Why does she park there? Because she can. 4 in the morning, there's no traffic out there. Does she think there's water underneath the bridge? Is that illogical thinking as you're crossing a bridge and you can't see anything? You cross a main waterway, the Escambia River, and you continue going until you find a place to stop. She probably had to wait that there was no traffic. It's towards the body. Did you ever think the body was going to be found again? Go to the next slide. You see the suitcase underneath the bridge. And as Macon Ponder testified, it was where he and his coworker found it. It was clearly someone who dropped it directly over the bridge. There was an imprint that you remember seeing pictures of, and they ended up dragging it under the bridge, not knowing what the contents were. More importantly, not smelling anything. Why is that important? Harley didn't smell anything. Body had been out here since February 4th. This is now March 17th in Florida heat. They didn't smell anything until the suitcase was open. That lends some credibility to Harley when she says she never smelled or never knew the suitcase was back in the back of the van. Anyway, they dump it out and they see that probably the most horrific thing anybody can ever see in their lives, scan his body in a fetal position, decomposed, wearing the same clothes that he was wearing January 7th, 2020. She killed him. Pants and a white stripe. Watch the video when they leave. See him wearing sweatpants with a white stripe. Talk about that more later. Let's talk about the law, okay? And as I go through the law, I'm going to later kind of go through the timeline of events. And I would like you to think about the mental states and sanity as I talk about those. So I want to talk about the law first. The first instruction I have up here is the elements of the crime of murder in the first degree after deliberation. You will see that most of these elements are not in dispute. That the defendant, not in dispute. In the state of Colorado, at or about the date and place charged, not in dispute. After deliberation and with intent, those are highlighted because those are the culpable mental states that are attached to that crime. Those are the culpable mental states in the insanity definition that we're talking about. So I want to highlight those in a second. To cause the death of a person other than herself, cause the death of a person again. Those are not in dispute either. And number 7 is the issue in the case. That's the insanity defense. I'm going to talk about in a minute. We can go to the next elements. After deliberation, not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. Now, some of you, before you came into court, if you never seen this definition, you're probably thinking about premeditation, where people are planning something out and it takes days to plan out the murder and then they finally do the murder. That's not what that definition says. It's just enough time to have judgment and reflection, to make decisions. To go from grabbing a knife, to go to grabbing some blunt force object, to go to grabbing. Is she exercising judgment and reflection? And it doesn't have to be good judgment. It doesn't have to be bad judgment. It just has to be judgment. Is she making a decision? A person acts intentionally or with intent when her conscious objective is to cause a specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. I don't want to bet money on it, but I bet you a lawyer wrote that definition. It just means with intent. What was their intent? Did she intend to kill Gannon when she did what she did to Gannon? I would suggest that that's not in dispute either. We can now go to the next crime, which is murder in the first degree, a child under the age of 12, and the defendant was in a position of trust. Now, the reason why there's 2 counts of murder, there's only one victim, is because this is just another theory of first degree murder. There's several theories of first degree murder in the law. These are the 2 that are in front of you now, okay? And as you can see, the mental state is what's different, and the age of the victim. And then the defendant has to be in a possession of trust. That's not in dispute. She's stepmom. She's obviously acting as Gannon's parent at the time that she. But let's talk about what knowingly is, because that's the culpable mental state with this crime. Person acts knowingly or willfully with respect to conduct or to circumstance described by statute defining an offense when she is aware that her conduct is of such a nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of her conduct when she is aware that her conduct is practically certain to cause the result. Stab someone 18 times, hit him over the head 4 times. When you shoot at him 3 times, striking him once, I think you might have an idea of what the result might be. I would suggest that that's not in dispute in this case. Let's go to insanity. These words mean a lot. This is not something that you're going to find in the DSM-5. This is not a mental illness. This is a legal definition. These are just like the elements of the crime that we just went through. The reason I say that is because, first of all, I'm going to start at the bottom. It says the law presumes everyone to be sane. There's a presumption of sanity. However, after some evidence of insanity has been presented, the burden of proof shifts to us, and we gladly accept it. Gladly accept it. Now, what does insanity mean? The defendant was insane at the time of the commission of the acts if he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to the act. That's why you heard me ask that question so many times. Or she suffered from a condition of mind caused by a mental disease or defect that prevented her from forming a culpable mental state, the ones we just talked about, that is an essential element of a crime charged. And then the next paragraph means something, because it says, but care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger. Passion growing out of anger. If you lose your temper, you don't get to claim insanity. Revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. So you can't lose your temper and come in and say, I lost my temper, I wasn't myself. We're humans. We have emotions. The next part is what's critical. It says, In addition, disease or defective in mind is not referred to an abnormality manifested by only repeated criminal or otherwise antisocial conduct. We heard a little bit about antisocial personality disorder. Who hasn't been diagnosed with that, but that's the reason why someone who has antisocial personality disorder, they have fun killing people, they lie all the time, they manipulate all the time, they have no empathy, they have no sympathy. Those people don't get to come in and say, I was living with Sam. Now, what does mental disease or defect mean? This is what the legal definition of mental disease or defect is. And I'm going to leave this up here for quite a while because I'm going to go through all the doctor's testimony here in a second. And I want you to look at that instruction as we talk about what they had to say. But first of all, it has to be a severe word means something. It has to be a severely abnormal mental condition that grossly and demonstrably impairs a person's perception of understanding of reality and that are not attributable to the voluntary ingestion of alcohol or drugs. Mental disease or defect does not include an abnormality manifested only by repeated criminal or other antisocial behavior. So let's talk about that. The word grossly and demonstrably. You think Harley might notice if she had a grossly and demonstrably mental condition? You think she might have shared that with you? You think Al Stauch might have noticed when it says it has to be grossly and demonstrably? You've got to demonstrate it, right? It's not something you snap your fingers and then all of a sudden go into a different personality. What about her brother? Howard. Think he might have noticed it? Let's talk about the doctors. I'm actually going to talk about Dr. Niederhauser first. Dr. Niederhauser was really the first doctor and all the doctors you heard from to see her. If you recall, she saw her on December 5th, December 13th, 30 minutes each time. Came in and remember the difference between a clinical evaluation and a forensic evaluation? Clinical evaluation. I rely on what the patient says. I rely just like if they came in and said, I've got a fever. I'm going to take that at their word and I'm going to treat them for what they're telling me. She comes in and says, I've got anxiety. Treats her for anxiety. She diagnoses her with general anxiety. And she told you on the stand that she had general anxiety at the time she's testimony. A lot of people did that came in and testified. That's not a severe and abnormal mental condition that grossly and demonstrably impairs a person's perception or understanding of reality. We all experience that. In fact, you got to experience her experiencing it on video. In January 29th, 2020, when she's being interviewed, remember at the end of the interview, she had to call the paramedics and she said she was suffering from panic attacks. The paramedics came in and said, your vital signs are not only good, they're exceptionally good. You're breathing fine. Your heart rate's fine. I don't know what the problem is. I think she might have been faking that to get out of the setting. Dr. Niederhauser also tells us that she had no history of inpatient psychiatric treatment, no history other than anxiety of any other diagnosis for mental illnesses. And this is based on what the defendant's telling her. No evidence of psychosis. No reason to put her on an M1 hold. If she was experiencing psychosis in December of 2019, the doctor would have had an obligation to come in. That's the kind of stuff that talks about severely abnormal mental conditions that affects your vision of reality. It's not there. The other thing about that visit, the timing of that visit, December of 2019. Remember, the whole purpose of that visit is so that she can get a letter to go to her employment because she didn't want to work anymore. The ironic part about it is at the second interview, the defendant tells her, I don't want to work there anymore. But I got a contract, so I need a letter to get out of it. But what else happens right before Gannon is murdered? Goes on a cruise. Goes on a cruise in January. You think that might have something to do with not wanting to go to work based on what you know about her and the statements she's made? Dr. Moore, Christine Moore, she works at the jail. She's a psychologist. She evaluates people who come in who are charged with serious crimes, perhaps their first time in a jail. They evaluate to see if they're a danger to themselves or others. It's a psychological evaluation. She said it was a clinical evaluation. They also want to know if there's any medication they might need. What the defendant tells her is that she has anxiety. I didn't do the crime, not going to be a problem. That was on March 5th, 2020, first day of her visit in the jail. Dr. Moore spent quite a bit of time with her up until January 5th of 2021, seeing her either once every 2 weeks or once every week, depending on what was going on with her. March 20th, she goes to her and says, I just want to see how you're doing. And his body was found. Never in Florida. The reason why I'm telling you this is because she doesn't say, hey, Maria Sanchez did it. Or, you know what? I got dissociative identity disorder. You're a psychologist. I need help. Nothing. In fact, she told you there was no evidence during the entire time she spent with her that she had dissociative identity disorder or any other severe mental illness that meets that definition. This was it was a little over a month after the crime, January 27th, March 5th. And then what happens on June 5th, 2020 in the jail? You recall Dr. Moore's testimony. She reviews all the deputies' notes to see what's going on with the defendant at the time, to see how she's doing. And she reviews notes from deputies that say, I'm going to start acting crazy. That's what the defendant says. And then on that very day, June 5th, 2020, she enters a competency issue into the court. That's how we get to the competency evaluations that I'm going to talk about here in a second. The timing of that. Okay, Gannon's body was found on March 17th. She finds out about it on March 20th. You know that she's read the discovery, the police reports in this case, and there's nothing wrong with that. She's entitled to read that. Point is, she's read it. And then all of a sudden, I'm going to start acting crazy. For another defense, no dissociative identity disorder, certainly no Maria Sanchez during her entire time or entire visits with Dr. Moore for that year period of time. The first competency evaluation was done down at the state hospital. You don't pick where she goes. The prosecution, when I say we don't pick what doctors do the evaluation. Court orders it, goes to the state hospital. Doctors are chosen, they do an evaluation. What's relevant about this first competency evaluation that takes place on July 20th, 2020 is when she goes to the state hospital, is that they have a 2-week observation period for nurses, employees are watching her. He actually goes to a nurse and says, can you tell when someone's faking it? Dr. Torres and Dr. Gray actually, they do a forensic interview with her on August 4th of 2020. Again, now we're in a forensic mode. Now we're not just going to listen to what she has to say. We're going to look at collateral information. We're going to call Al Stauch. We're going to try to call Harley. We're going to try to call family members to see if we can corroborate what she's telling us. So what does she tell them? I've got bipolar disorder. I'm a manic depressant. I ramble. I'm a manic depression. That's my mental illness. Nothing about dissociative identity disorder, which according to Dr. Lewis, she's had it since a very young age. Nothing about Maria Sanchez. Remember Dr. Torres's testimony when she was talking about the competency evaluation? One of the psychological tests that she took had a question about multi-personalities. And the answer led Dr. Torres to ask her, hey, do you have multiple personalities? This is August 4th, 2020. Dr. Gray and Dr. Torres diagnosed her with specified personality disorder with borderline and narcissistic features. Talked about that a little bit. Now, does it meet that definition? How do we know if it meets that definition? Her actions. How other people perceive her. Also, Dr. Torres said you, no, it's not a severe mental disease. It's not something that affects her everyday life, that affects her ability to make decisions. No evidence of psychosis during that evaluation either. No history of inpatient treatment during that evaluation. Psychological testing. MMPI-2. Remember that test? What does that test tell you and told Dr. Torres and Dr. Gray? That she exaggerates psychiatric to the point where even people who are hospitalized for their mental illness don't answer questions that way. You think she might be faking it? Now we go to the second competency evaluation with Dr. Grimmett. Now, remember how Dr. Grimmett became involved in this case? The defense at the time, and it wasn't these defense attorneys, requested that she do the evaluation of the second competency evaluation. We had nothing to do with that. So now this happens on December 22nd, 2020. That's when Dr. Grimmett talks to her. And so I want you to think about how it's progressed now. Now she starts talking about dissociative identity disorder and bipolar disorder. When I say she, the defendant. That's what the defendant is telling Dr. Grimmett. She says she has 4 distinct personalities. None of those 4 were Maria Sanchez. Remember what Dr. Grimmett testified to? That she was, first of all, creating these names. Second of all, like Jasmine was a Disney character. Talked about vampires. Twilight. I've seen the movie Twilight. I know I hate admitting that, but I've seen it. And she cited the characters from that movie. And Dr. Grimmett said, wait a minute here. You're just telling me characters from a movie? That's not dissociative identity disorder. But she evaluated her for it because that's what she's telling. Dr. Grimmett evaluated her for DID. Said, no, not there. I don't even need any more information. I don't need to rule it out. Not there. She also diagnosed the defendant with other specified personality disorder with borderline and narcissistic features. She also told you that it doesn't fit that definition. Jump forward to February of 2022. I don't know when the conversation took place, but at some point before the defendant pled not guilty by reason of insanity on February 11th, 2022, they had a conversation, the counsel had a conversation with Dr. Lewis. Remember, Dr. Lewis testified that I recommended you change your plea to not guilty by reason of insanity. Why is that important? Why did I ask her about that? I think that put a little pressure on her. And she says, I recommend you plead not guilty by reason of insanity, and I'll do the evaluation. Why didn't she do the evaluation right away? Why'd she wait till November? Come out and talk to the defendant. Needless to say, when she pled not guilty by reason of insanity in February, the same process happened as happened when she raised competency. Sent down to the state hospital. The state hospital chooses who's going to do the evaluation. They make a decision on who already knows the case. Dr. Torres and Dr. Gray already read all the discovery in this case. They knew the facts of the case. They knew the defendant, but they're doing a different evaluation. As you remember, competency goes to her state of mind at the time they're doing the evaluation. What's her understanding, what's happening in the courtroom, whether or not she can get along with her attorneys, that kind of thing. Insanity is completely different. Insanity, you got to go back, just like the law says, at the time of the crime, what was her mental state? So that's a much broader evaluation. You got to look at everything. So Dr. Torres and Dr. Gray, they also reach out again, call out. They attempt to talk to Harley, family members, to see what's going on with her. But what is the defendant saying now? Gone off of bipolar now. And now she's created more personalities as part of this dissociative identity disorder. Is it just a coincidence that she's consulted with Dr. Lewis prior to all this? Now Maria Sanchez comes into play during this evaluation. Dr. Torres testified, and it's in a report, that she said, there is no credible evidence to conclude she has a condition that conforms to the definition of a mental disease or defect. Pretty powerful language. That's powerful language. No credible evidence. What's also interesting about this evaluation compared to Dr. Lewis's evaluation is they do two interviews, if you remember. One was in March, one was in June. The March interview, I think I couldn't count how many questions, but it wasn't a lot of questions asked. It was the defendant talking. They just let her go. In June, they asked more questions. One of the questions that Dr. Torres asked is, can we talk to Maria? Can we talk to Maria Sanchez? She said, no, Maria just doesn't come out. There's got to be some kind of stressor. There's got to be a triggering event, which coincidentally is exactly what the DSM-5 says. I can't just summon Maria. You saw on Wednesday how that happened, and it was magic, according to the Dr. Lewis. No severe abnormal mental conditions that grossly and demonstrably impair a person's perception of understanding of reality. No psychosis, no bipolar. Because remember the first competency evaluation, they said they had to rule it out. They've ruled it out. Bipolar does not exist with this defendant based on Dr. Torres and Dr. Gray. They also said no dissociative identity disorder. Didn't have to rule that out. They had enough to say there's no credible evidence. That's not there. They continued on with the diagnosis of other specified personality disorder with borderline and narcissistic features. Dr. Torres and Dr. Gray came to the conclusion that the defendant was not legally insane at the time of the crime. Let's go to the next slide, which is the credibility instruction. This instruction applies to experts as well. May believe all the testimony of a witness, part of it, or none of it. This instruction applies to every witness who testifies, including Dr. Lewis. I got highlighted certain words there. Motive. Didn't see motive in the elements of first-degree murder, but you see it here. Money is a strong motivator. Having shows on HBO, strong motivator. Having your son videotape evaluations on a first-degree murder case that's gotten quite a bit of publicity for perhaps another documentary is motive. You're gonna do a documentary if she says she's saying, sorry, did what I could. Acting. Not as good as, well, not as bad as Robert De Niro, I guess she would say, but she's acting. You also have to look at her demeanor and manner while testifying. Wouldn't answer any of my questions. She wouldn't answer my questions. Because she didn't want you to know the answers. She wanted you to know what she wanted to say. She shows up to court late. Talk about narcissistic tendencies. Manner while testifying. I think that speaks for itself, how she testified. Especially when you compare Dr. Torres. Obviously she would disagree with my questions. Every how many times she says it depends to me. She's not our expert. This happens to be the expert that the state hospital chose to come in to do a neutral evaluation, the truth. Dr. Lewis. She didn't know the legal definition of insanity in the state of Colorado, ladies and gentlemen. The whole reason she came in to testify. I'm not even sure what her opinion is anymore, based on your questions at the end. Remember how she answered it? About the MRI and the EEG that she withdrew? My opinion is ongoing. What does that mean? Does that tell you that her opinion that she was legally insane at the time counts for anything? Because when you think about her report, she does this preliminary report, which was supposed to be an insanity report, 35 days before trial, that says, hey, I need more information. I need an EEG and an MRI done if I'm going to make a decision on insanity. Well, that doesn't happen. MRIs, you take someone to the hospital for 2 hours, you do an MRI, you come back. Never happened. But yet, a few days before trial, she hands over a report saying, I find her legally insane, and that's literally all she says. Don't know what standard of insanity she's using. What I do know is she didn't get the information that she needed. But you know what information she had? She had a third MMPI-2 test that Dr. Torres told you about, that a Dr. Leach took, that was hired by the defense to do psychological testing based on what Dr. Lewis requested. Guess what the results of that showed? It was the same, exaggerating psychiatric symptoms to the point where people who are hospitalized for mental illnesses would not answer those questions that way. That didn't seem to matter. I want to talk about the facts of the case, and the reason why I want to do that is because I think it's important for you to look at the defendant's actions before, during, and after she killed. I'm going to start with the video of Gannon's burns. Just
Two, I just don't know what to do.
Well, devastating. Initially, Scott, I can't lie when the TMZ information.
Shannon, I promise this is the last time I'm gonna ask you. I'm just freaked out, okay? Are you sure you didn't do it on purpose? Okay, you promise. You promise. Pinky promise. Okay, all right, so listen. All right, we're gonna have to sell stuff to fix it. Okay, so we figure out what we gotta sell. We can sell the sofa. We can sell whatever, because we gotta get it fixed. So lady, don't be mad at us and kick us out of the house. Okay? You got it? You got it?
I'm just worried about my.
Okay, shh, listen. So tomorrow,
Why is that important? Why is she videotaping an 11-year-old boy who has burns? More importantly, why did she stop videotaping a little boy? And I think it might be because Gannon said, I'm just worried about my burns. I think that was the purpose of that video. I think that's using judgment and reflection. Now, the hydrocodone. I can't stand here and tell you how that got in the Gannon system. All I can tell you is there's only one person there that could have. Did she give it to him because of the burns? I don't know. But when she gave it to him, do you think that's using judgment and reflection? January 27th. This is actually at 9:46 is when this video was recorded. Monday night. The next morning, January 27th, 2020, at 4:36 in the morning. Decision was made for her, or she made the decision to text Mix Hicks saying, my stepfather had just been killed in a car accident. Or words to that effect. Ms. Hicks responds later on saying, I'm sorry, please let me know. And I'm paraphrasing, I don't have it memorized. But she says words to the effect, please let me know if there's anything we can do and when you can come in. She responds back, the defendant does, by saying, why are you being so insensitive? This is a family member that just died on the East Coast. Why is that important? Because that's the theory that Dr. Lewis wants you to believe. The fact that she makes this text about the stepfather is somehow tied to the killing of Gannon. Some years later. It just means she didn't want to go to work that day. Could it possibly mean that she knew what she was going to do when she said, and tomorrow? And shortly after that, she calls Gannon school, says he's not coming in today. And she texts Al Stauch and says, hey, I'm going to make up an excuse, not go to work, which she does. And Gannon's not going to go to school because of his stomach issues. Judgment, reflection. Then on that same morning at 8:14 and 8:16 a.m., she takes that picture of Gannon in bed. Why did she take a picture of Gannon in bed in his bed? And text it to Gannon's father, Al. Look, Gannon's alive. He's here, he's sick, he's in bed. You heard Al Stauch testify a little bit about Gannon He has ADHD. Hyper. It's still at 8:14, 8. I think he might be lethargic from hydrocodone. Why he's still in bed? Think she wants to prove that he's still alive because she knew how much hydrocodone she gave him? Is that a rational reason to do it? Does that make sense? January 27th at 9:54 a.m. Text Al from her phone. This was your question, by the way. She texts Al from her phone saying, I left my phone at home before she left the house. You think that's an indication that she knew what was going to happen? Is it that far-fetched to think that she knows Gannon had been poisoned and that something might happen to Gannon? Then at 10:12 a.m., they leave in Al's truck. And again, this is the video that you saw that you can see his pants with the white stripe down him when they leave. You see him get into the back seat of the pickup truck, and Stauch gets into the driver's seat. They drive away. What the heck is she doing taking a sick kid out to go shopping for dog clothes? Narcissistic tendencies. Not me. Dogs. They're gone until 2:20 p.m. when they come back. You saw the videos. She drives in the back of the driveway. She's got to back in and then drive back in. Eventually the truck comes to a stop. They're stopped in that driveway for 39 seconds. What are they talking about in that truck? Doors open. You see the leg drop. You see Gannon beeline right through the garage. You see the defendant going after. At 2:26 p.m., you see the defendant come out and move the Tiguan from the driveway, back it into the garage. What was the need at that moment to back that Tiguan into the garage? Then you see her come out in the front of the garage, out in front, below the garage door, and look around. Back in the house. This is when the murder happens, ladies and gentlemen. 30. Right in that time frame. There's no activity on her phone. And does autopsy. Axe him with a knife. Good enough. And he fought when he was born. He's fighting now. On 1 pound, 6 ounces. Get it through that. Coming after him. Goes to get a blunt force object, crush his skull. Not sound like rational thinking, but it's certainly thinking. That's the before and during. A lot to talk about. There's so much to talk about after. She stuffs him in a suitcase. She drags his body to the storage room, opens the large green suitcase, somehow manages to squeeze him in there, gets the blankets off the bed, wraps him up in that, pillows, picks up the shell casings, does something with a knife, does something with a blunt force object. She sticks him into the storage room and throws boxes on him. At 3:11 p.m., Al texted her, said, "Are you sleeping?" No response from the defendant. Lena gets home. She gets to the house about 3:15 p.m. The bus comes by about 3:11 p.m. Doesn't let Lena in the house. She makes Lena stay outside because she's got work to do. Got to clean that bloody mess in that room. Got to hide evidence. Got to tamper with things. Dan's dad texted him at 3:35. Said, "Hey, buddy. Having no clue what she did to him." No response to that. No one read that text until 7:40 that evening. That was the defendant reading it. 6:27 p.m., the defendant texts Al and says, Gannon went to a friend's house. He was supposed to be home at 6. He's not home yet. 6:55, she calls 911. You heard that call. How can she do this? How can she talk to Gannon's father like nothing happened? That traits of an antisocial personality disorder, the fact that you can have no sympathy, so cold and callous, and act like nothing happened. And she does it through the whole day. You guys know that. She calls Landon on Gannon's phone a couple times that night. Is that a trait, an antisocial personality disorder? Landon gets a call from Gannon. She knows he's missing, and it's her. Next morning, January 28, 2020, at 6:22 a.m., you see the T-Bone leave. It's gone for 10 minutes. What is she doing? Is it beyond the realm of possibility that she's doing a practice run to see if anybody's watching her? She's about to move the body. Is that beyond the realm of common sense? She again comes back, backs into the garage. Heard evidence that she'd never backed that Tiguan in the back of the garage until that day. They leave. When I say they, Bandit and Gannon's body. Go to the airport. Leave the house at 8:13 a.m. They get to the airport about 8:30 a.m. She's made the decision to rent another car. She even left the house. Is that evidence of psychosis? Or is that evidence of thinking things through? I'm going to leave Gannon's body in the back of that T1 at the airport. We're going to pick up a car. Al's didn't care because we don't want to put mileage on my leased vehicle. Al gets off the airplane. He's just worried about Gannon. Where's my son? You think at that moment he cared that she rented a car? But she made a big deal about, hey, I don't want to put miles on my T1. She never searched for Gannon. They go to the interview at Starbucks at approximately 1:30 that afternoon. They had that interview, you heard it. After that interview, she disappears. Takes the rental car and it's gone that afternoon. No one knows where she's at. We do. Is that Life 360 at? We got her going back to the airport at 4:41 p.m. We have a parking ticket that was found inside the white Kia rental car that says she went into the airport at 4:41 p.m. Now, she must have got out of there quickly because she never had to get another ticket when she left. But we know from Life 360, and we know from the telegraph on the Tiguan that the Tiguan didn't leave, that she leaves the airport shortly after that. What is she doing at the airport? Is it that crazy to think that she's checking on Gannon's body in the back of the Tiguan? Does that sound like someone doesn't know right from wrong? Does that sound like someone who's trying to get away with something? At some point that afternoon, as Al Stauch is out looking for his son, he goes to French elementary school. And he goes there because his wife, the defendant, says, I left the Tiguan there. That's a critical moment in the investigation because when he sees the Tiguan is not there, he now knows that his wife had something to do with the disappearance of Gannon. And the investigation starts to look at her. Because he has a second interview that night, he tells the police, you know, I didn't think much about that rental car until I went to French Elementary and I didn't see the Tiguan there like she told me it was. At 5:25 p.m. that night on the 28th, she tells Al Stauch, you need to get an attorney. 7 p.m. she returns back to the airport. She parks that white Kia in short-term parking, keeps the keys, and drives off in the Tiguan and exits the airport at 7:03 p.m., very close to that time. Got the ticket. You've got the ticket. We got the telematics and know exactly where she goes. Got the text messages between her and Harley. Clearly show that she's manipulating Harley, her own daughter. Don't let the police in. Don't talk to the police. The pizza guy? All right, you can let the pizza guy in. If she's manipulating Harley, do you think she's manipulating Gannon? Do you think she's manipulating Lena? Do you think that's manipulation, the video you just saw? You're gonna have to sell stuff because the lady's gonna be upset with this, the owner of the house. Goes to the S-curve in Palmer Lake. You know that at 9:23 p.m. She's there for at least 5 minutes. We don't know why actually she's there. We know that the board was found there sometime in mid-February when we started searching there based on the information we had from her Life 360 and the telematics. We know that board had Gannon's blood on it. DNA matched it. Why is she going out to hide the body there? I don't know. Probably because it's a good location. She can't keep it in the Tiguan. She know right from wrong? At 12 a.m., 28th into the 29th, Harley drives out to her employment to pick her up. They leave the Tiguan there overnight. This whole time while she's missing and dumping Dan's body up in Palmer Lake, Detective Bethel is trying to get her to come in for an interview. Remember that? Al Stauch's trying to call her to get in for an interview. Planes or her phone's on airplane. The next morning, Harley drives her to the airport. They drop off the keys to the Kia. When I say drop it off, they threw the keys to the Kia to an attendant, left. That rational thinking? That someone who didn't want to get caught? Text at 10:25 a.m. on the 29th. I'm on my way to Detective Bethel. The interview. Takes her over an hour and a half to get there. We know that the car is washed on the way. You saw photos of the water dripping off of it when she gets there. The interview she gives, you watched it. I'm not going to get into all the details. I just want to emphasize that she plants seeds. The suitcase is critical. Who says that? I think it was Eduardo at this time. Eduardo also took a suitcase when he took Gannon. She knows where the suitcase is at up in Palmer Lake. On January 30th, 2020, her family shows up. Dakota Lowry, Brenda Awkward, and Deborah Locklear, her mother. Flying to Denver, they rent that Nissan Altima and drive down to Colorado Springs. They pick them up, take them to the extended stay suites hotel. The next morning, they rent that van, Brenda Awkward does, to collect their stuff at the house. They get her suitcase, including that red or pink suitcase that we recover in South Carolina that has blood on it that happens to match Gannon, with a blanket inside it that happens to match Gannon. Pretty strong evidence. You got blood of the victim that you just killed with you when you're arrested on March 2nd. But what happens after they load things up? We know the suitcase was not there because the police were checking everything that came out of that house. We also know what Dakota said about when they exchanged vans, that he saw that very same green suitcase that was under the bridge that day, and she says she had softball equipment in it. But when she gives the interview with the KKTV reporter at 12:10 p.m., well, let's just look at her words. What are her words? We can play this video.
You are,
I am Tisha Stauch, which is Gannon's stepmother.
you've been a part of the investigation since the very first time. You were the last person to see him. Is that right?
Correct.
What did you see when you last saw him?
Well, I'm not allowed to talk about anything with the case. I would more so be willing to talk about how the community needs to have faith and continue to work together and not make these false accusations. And I would never, ever hurt this child. And I know there's some questions out there about, okay, so tell me what happens. That's up to the investigations when they end up letting you guys know. But I've cooperated with them, even to the point that we were held with a gun. And my daughter, a 17-year-old who serves our country in the United States Air Force, who has never committed a crime or done anything wrong in her life, was put in handcuffs over the keys that was in her purse so they could take her car. I'm just ready for Gannon to come home. Most importantly, for him to see his family. But second, I am going to be so ecstatic when I'm able to say to people that I hope they have a really sincere apology for all these theories that have came out online, for all the things they said that I have done or people have done. And I just want everyone to know that we're going to find Gannon.
Can you talk to me a little bit about him? I don't know it.
Gannon is so kind and he loves to play video games. That's one of his favorite things. He loves Sonic and Mario. And, you know, he's always helpful. And he was always so helpful with the dogs around the house. And we have 2 little cute dogs. And he was always like a person I could say, Gannon, can you go do this? And he would do it right away. You know, sometimes with kids, we have to remind them and things like that. And that's okay. But he was so sweet and able to help anyone. He could notice when you're sick and say, are you okay? And such a kind heart. We should all come together and wait until the end and see what happens, because Gannon's going to come home.
Any message for Gannon?
The message for Gannon I have is, Gannon, when you get here, you'll be able to truly tell what happened. And then I really hope I get a sincere apology from everyone who has made all those things, especially from my husband.
What we just heard there, that evidence that she might have some antisocial trait. Calmly talk about that to a news reporter. She's done. I failed to mention Amanda Van Nest, who was the same nurse who examined her for injuries based on what she was telling people. First interview that she was raped and she examined her head and found no injuries. But what else did she do? She also told you about M1 holds. And if she would have noticed anything that would require her to have a doctor examine her for an M1 hold, she would have done it. No evidence of mental disease. No evidence of psychosis. And this is the 29th, 2 days after she killed him. We know that a GPS tracker was later placed on that Nissan Altima, and you know where she went when she disappeared for 2 hours and told her family that she was going to a pet store. Got her right back at the Isker. She picks up Gannon's body, puts him in the trunk of that Nissan Altima, leaves the board out there, later found, and drives back to the hotel after she goes and gets some more dog outfits. And when she gets back to the extended stay suites, she's got to move Gannon's body from the trunk to the van that Brenda Awkward rented earlier that day. We know that had to happen because of Dakota Lowry's testimony. Her and Dakota go to the budget rental van place the next morning, February 1st, and they've got to move all the suitcases from one van to another. That's when he sees the green suitcase, knew something was suspicious about it. You saw his reaction. had to get on a witness stand. He got subpoenaed here to come here. I think he felt manipulated by this defendant. You know the rest of the story. She drives across country with Harley. She's using the Ford Motor Company to check in the hotels. They got a little scheme you saw in video. Harley would go in with the dogs. She'd check in as one person. All rational thinking. It's also by social personality traits, perhaps. They drive all the way to Florida. They get there February 4th. Another divine intervention. The power up at 4:36 in the morning in between the hotel and where Gannon's body is found. Every 24 or 25 hours it happens. It happens at that moment. That tells you that van is on the move in the middle of the night. Tells you she dumped Gannon's body that night or the early morning hours of February 4th. I'm going to go through fast now because I've been talking way too long. I want to talk about the pretext phone calls. You know all the stories. I'm not going to get into the details. Eduardo, immunity, Quincy Brown, several different versions of that. Bike accident, Uncle Matt. One that significant, and she says, I'm so sorry, Al, for lying to you. I'm going to tell you the truth. Wasn't in the car when I left Petco. He wasn't in the truck. Fake pregnant lady with cash. She's laundering money. She's arrested on March 2nd, 2020. She comes up with a story of now how it's Angel, the babysitter, who did it. Suitcase with Gannon's blood found on her. We've got all the searches on her phone that I'm not going to go through. You just saw it a few days ago. But what I'd like to talk about is what people who are truly legally insane do under these circumstances. Because there are people who are truly legally insane, ladies and gentlemen. They don't act like that. If they don't have the capacity to know right from wrong, they're not going to hide the body. They're going to act like nothing happened. They may even do the crime if someone's there watching them because they don't know that it's wrong. Do you think she would have done this to Gannon if anyone was in the room with her? Of course not. They also don't lie. There's no reason to lie because they don't think it's wrong. So they come in and they say things like, my God, I heard a voice that I thought was the devil. And the devil made me do this. I had no choice. Why are you even talking to me about it? That's what we're talking about when we talk about a severe mental disease or defect. When we're talking about the capacity to form the intent or the capacity to use judgment and reflection, I'm going to refer you back to Mice and Men, the book. I read that a long time ago, but I still remember. It's about George and Lenny during the Depression. And George is a smart one. Lenny has some severe mental illnesses. Lenny likes to pet rabbits. He's such a big guy that he doesn't even know his own strength. So he would pet rabbits to the point where he would kill them. That's what we're talking about when you don't have the capacity to form the intent to kill because the mental illness doesn't allow you to. We're not talking about someone who makes choices to get weapons to kill with. I appreciate your patience. I know I've talked a long time here, much longer than I thought, and I apologize for that. There's only one right verdict in this case. That's guilty to each and every charge that she's charged with. First-degree murder after deliberation, first-degree murder child under the age of 12, tampering with the deceased body, and tampering with physical evidence.
we switch over?
Yeah, they did. The oh, whoops, wrong one. Sorry, my bad. There you go.
The one thing they cannot answer, because there is no answer, is motive. Motive for why this happened. Motive how we can go from this picture on a hike up at Garden of the Gods, loving, kind, to less than 24 hours later. Brutal rage, 18 stab wounds, 4 blunt force trauma, shot. This wasn't a pre-planned, calculated killing for some gain. This was a psychotic break fueled by rage, attacking a demon from the past. They cannot come up with a motive because there is no motive that makes sense, ladies and gentlemen. They have tried. They have spent hundreds, if not thousands of hours trying to come up with one. They've gone through phones. They have gone through iCloud accounts. They have gone through Facebook messages. They've interviewed everybody who they could possibly think of to try to find some motive. None of what they have done in this, the biggest investigation in the history of El Paso County, has come up with a motive. No one who they have ever interviewed has ever said that she ever had a problem with Gannon. No one who they have ever interviewed has ever said she was ever mean to Gannon. No one who they've ever interviewed or come across anything has said she's ever done anything wrong to Gannon until that horrible day when this happens. That is the evidence, and the most strong evidence to know this was not premeditated murder. This was a psychotic break. That is the only thing that makes sense. And when you can pull yourself back and peel back the layers of the anger over the act, at the anger over the deceit in which it happened, at the anger over Gannon's body being driven all the way to Florida, when we take those emotions back and we try to look at this rationally, the only thing that possibly makes sense is a psychotic break. There is no other rational explanation to understand why this happened other than that. He was a special needs teacher, elementary needs teacher. That's what she'd been her entire life, working with kids with special needs. She was a mother to Harley, did everything she possibly could for Harley. She was a wife to Al, and she was tried to be the best stepmother she could be these kids. So much so that she was left with the kids for very long periods of time. In the months preceding this, when Al had gone up to Alaska, he had left his 2 kids in her care. He was gone. We were about as far across the country as you could possibly get. And based upon his relationship with her, based upon him seeing her as a loving stepmom, felt comfortable leaving his children with her alone in South Carolina. And he did that because he knew her and he saw that relationship she had with Gannon, and he felt comfortable based upon what he had seen with her. And he felt comfortable enough that when this was going on, he felt comfortable enough to leave to go to Oklahoma. Because what he had seen and what this photo shows is they had a loving relationship together until the evidence shows that she had a psychotic break. That something, mental illness from her past, got triggered, and there was a temporary period of psychosis. That's the only rational explanation that had been presented. And there is nothing else they can come up with as far as motive. Ladies and gentlemen, does it make sense that she may have Google searched maybe moving to Florida? Yeah. People have problems in marriages. Do people fantasize some about getting out by Googling stuff? But how would brutally murdering Gannon, how would stabbing him 18 different times facilitate that move? It wasn't. There's no rational basis behind the murder other than psychosis. The fact that she may have years before at some point in time done one Google search out of 1,000 saying, I don't like my stepson. That's not what I see there in that picture. That's not what I see there going on in the days leading up to this horrible tragedy. What it does seem to indicate, ladies and gentlemen, we start looking at this time frame, looking at the reliable evidence that we have in front of us, is that somehow that fire set off some type of trigger. Maybe some type of trigger that had been disassociated long ago. But we have her starting meltdown right after this fire. Ladies and gentlemen, Dr. Lewis used the term wacky a lot, maybe not the most scientific term, but when something seems irrational, when something doesn't seem to make sense, we have to consider mental illness. We have to consider possible psychosis. I would say that video that you heard up there, listen to the tenor of her voice, listen to what she is saying. She says, I'm freaked out. And when you listen to her voice, she is freaked out. And she's saying irrational stuff like, we're going to have to sell the sofa. Stuff like that to Gannon. That makes no sense there whatsoever. And then importantly, ladies and gentlemen, we also see mania starting to settle in when we start looking at these timelines specifically. We up there, they're texting back and forth, 10:15, Harley comes home, 10:24, 11:30, she's still talking to Al. $2:48, she's texting Al. 4:36, texting the school saying that her stepfather passed away. Her stepfather who had abused her was not, and you heard it from Dr. Torres at the state hospital, they are not doubting or disputing the abuse that she suffered growing up. And that's from Dr. Torres, who had investigated this, who had medical record provided, who had family members provided, who interviewed other family members, and she says the state hospital is not disputing the horrible trauma that she grew up with. And the person who she had suffered that horrible trauma from, that's who she calls and says dies at 4:36 in the morning. What is more important by this, ladies and gentlemen, important to look at, what is also that we see, what is she not doing? She's not sleeping. She is manic at this point in time. She is texting throughout the night, 2:48, 4:36, 4:36 again, 5:03, 5:49, 7:32. She is up the entire night and not sleeping. There is something going on with her head that is not seeming right. There's stuff going on through the day. The text messages back and forth. Harley leaves for work. Other conversations going on. And then they leave, they go up to Petco. Ladies and gentlemen, Mr. Young has tried to insinuate that all of this was some type of big preconceived plan, that she had made some decision earlier on at that point in time that she was going to kill Gannon. Ladies and gentlemen, does that make any sense? If she had decided at that point, early in the day, when everybody else leaves, Harley's left for work, she's just there alone with Gannon by herself. If there was a decision that was made that for some reason they cannot explain that she was going to brutally murder him, why is she taking him in the car and going up to Petco to buy Valentine's Day outfits for the dogs? That makes absolutely no sense why she would push back a timeline to just an hour or so before Lena got home, for some reason, unbeknownst to anybody, commit this brutally horrific act. Mr. Young tried to comment a lot about the hydrocodone. Be very careful when they try to put facts in their opinion or what they would like them to be that was not provided by any of the witness testimony. Dr. Ignacio testified that there was hydrocodone in the system. She never made any assertions about how much, whether it was a dangerous level, whether it was inappropriate, whether it would have been affecting him whatsoever that way. All she said is this was a tox screen, this came back. That's Mr. Young's opinion that somehow this was an overdose of hydrocodone, but there was no evidence of that by their expert. And there is no basis that would be for a brutal, horrible attack on a young 11-year-old boy that she'd just been hiking with up there 24 hours earlier. Something is going on in her mind. Something is there losing it. And something horrible occurs in the basement where there is a brutal, brutal attack. The brutality of the attack, ladies and gentlemen, I would say is the strongest evidence in this entire case of a psychotic break. That type of violence wouldn't be needed to kill an 11-year-old boy. Gannon weighed 85 pounds, 11-year-old kid, not the biggest 11-year-old kid, not the strongest 11-year-old kid, fun, nice kid. What do we know about him? He likes to play a lot of video games, but not needing this type of brutal, horrific rage to kill him. And there is no other, again, explanation other than the psychotic break. Lena then comes home, and ladies and gentlemen, look on that video. Lena wasn't pushed outside. Lena wasn't allowed. Lena came in the house. She's in that house for about 10, 15 minutes. And then she goes out and gets on her bike and leaves. The idea that Lena was never allowed in the house is a fantasy that is not supported by the evidence, that is not supported by any of the videos. Okay, that is Mr. Young's opinion. But look at that video. You see her going in the house. You then see about an hour later, Harley come into the house. And we know that Harley came in the house, and Harley actually went down in the basement. Why do we know that? Because she changes out of her uniform before going to the dollar store. So there is nothing in there that these kids were kept out of this house, and there is nothing to indicate that this was pre-planned that would keep this type of information away from them. What is going on in her head? We don't know. But here's the important thing, and here's what Mr. Young is trying to do. He is trying to introduce antisocial personality disorder into this. Because I would state to you, ladies and gentlemen, there are only two things that account for her actions at this point in time, for the remainder of this day and the days preceding, is either disassociation, where she has put that memory of this brutal attack of what she did to Gannon someplace that she doesn't have access to, and she doesn't understand what's going on or where Gannon is, or what she had done to him, or antisocial personality disorder, that she's some type of psychopath. Mr. Young, remember back to Dr. Torres, tried to interject many times with Dr. Torres the possibility of antisocial personality disorder, and Dr. Torres was firm. No, she does not meet the criteria for antisocial personality disorder. One, there's no past criminality with her. That's an element that you need for antisocial personality disorder. Other people with antisocial personality are unempathetic to people and don't care about people. Again, for her entire career, she was a special needs teacher, teaching kids, helping kids who have disabilities. Through her whole life, that had been her career. That is not a psychopath with antisocial personality disorder. That it could be somebody with a dissociative disorder, either DID or borderline personality disorder with dissociative features, who has kept horrible trauma in her past behind her and is trying to make the lives of kids with special needs better for them. That is somebody with empathy who does that whole thing. Ladies and gentlemen, I would put before you the strongest evidence of disassociation going on here. Look at the body-worn camera of the sheriffs when they come in that night looking for Gannon. The most horrible, brutal attack has happened before there. Gannon is in the house in the suitcase. It has all been recently covered up. She's there with her daughter. She's there with Lena. And she's acting and presenting herself to these police, laughing, joking, being incredibly friendly just after this has happened. Because at that point in time, she has disassociated the horrible act that she has committed. There's no other logical explanation for how that she is doing that. And when you go back and look at these timelines, ladies and gentlemen, look and go through them. What is really important during this whole time, she is not sleeping at all. For the whole time period that this is all going on, you see activity going on her phone or things that she's doing all through the night. She is in a manic situation and her mind is not working. Again, we heard Dr. Lewis talk about irrational things that she is doing that doesn't make any sense. Ladies and gentlemen, It makes no sense for somebody who has pre-planned for whatever reason, whatever motive, to brutally kill Gannon, to then report him missing right away, and then in a matter of 3 days later, go into the police with a completely illogical, incoherent story. You've heard different witnesses. Miss Stauch was an intelligent, above average intelligence woman, a smart woman, everything like that. To go in only 2 days later and sit down with the police and come up with the ridiculous story of Eduardo is not the actions of a sane, rational person. Is irrational belief. Even children know. If you keep saying different stories, you're not going to be believed. Even looking back at the little boy who cried wolf, which we teach children, if you keep making up things, then you're not going to believe. She changes her story, not only completely different, not only with no explanation as to really why she had made up the prior story to one that she is changing now, but comes up with this ridiculous thing that she met this Eduardo, that he was just going to come over and fix the carpet for free. She's indicating she's not even planning on paying him, that somehow he is in the garage when they get there, that he then takes her down into the basement and rapes her for an hour, and that he takes Gannon in a suitcase and leads out of the home. That are not the actions of somebody who is sane and logical. That is completely irrational to believe that that kind of thing could possibly be believed. Her actions, I would say, continue to be irrational. She keeps changing her story. She keeps giving different accounts. Gannon is placed in the suitcase, driven all the way to Florida. She goes through Louisiana. She goes through all kinds of East Texas, all kinds of places where people are not around, deserted areas, long areas of desolation, many places where that suitcase could have been hidden and never been found. And she goes all the way to Pensacola for it and drops it off at a dry space under a bridge right near a major city. That's not the actions of somebody who is rational, who is trying to hide that away. She then goes to South Carolina, and you can look at the Google searches that she performs in South Carolina. Face transplant near me. Like she's Googling for a McDonald's or a restaurant that's very close to her. This is going to pop up that she's going to go over there and get an entire face plant to change the way she looks. Those are not the actions of a sane and rational person. Those are the actions of somebody that is delusional. Ladies and gentlemen, I would say all of these pretext phone calls with Al are the actions of somebody who is delusional. Listen, go back and listen. Listen to those February 14th phone calls between her and Al. Listen to how her voice and tenor changes between phone calls. Listen to how her emotions switch rapidly during the phone calls with Al, and her stories switch rapidly that no sane, rational person of overintelligence could possibly expect anybody to believe. She is freaking out, and she is delusional in the thought that anybody is going to believe all the different variations that she's trying to sell them. None of that is rational. None of that makes sense. And so again, what then we're brought back to is why. What was going on? What preceded this? And looking, it's going to end up in the mental health experts. And I want to talk a little bit about Dr. Lewis. She is 85 years old. She has been doing research, treating, evaluating people with serious mental illness for over 60 years. She's one of the foremost experts in the country on dissociative identity disorder. She has been published in peer-reviewed journals well over 100 times. things that educates other psychiatrists and things that educates other doctors. She has authored and produced. She has done, she has the HBO documentary. They don't go just to quacks to do an HBO documentary. They went and they did a documentary on her because she was groundbreaking in her field. Has she consulted on other stuff with Robert De Niro and so forth? Yes. Not because she's a quack, because she has explored and she knows more about this subject than almost anybody else in the country. Has she, in her age, some of the details, the minute things in the discovery get lost a little bit in her memory? They do. And you saw that up on the stand when she was testifying. I'm not disputing that. But what she has is the decades and decades of experience with this, the decades and decades of dealing with people with severe mental illness who commit heinous acts. She has that experience to rely upon, and she had 14 hours of interviews with Ms. Stauch to talk with her, to base her opinion. She had notes from family members, other types of things to show this. And in her expert opinion, is legally insane. She wanted the EEG and the MRI to possibly know if there was also organic brain damage going on here. There was some type of brain trauma that was contributing to the mental illness of Ms. Stauch. What you heard at the end is she did not need those type of things to make the diagnosis of dissociative identity disorder, which she was confident on and she believes upon. Ladies and gentlemen, I would ask you, do not discount her decades of experience. Do not discount her expertise. Okay? The acting that this is a woman who has pioneered this, a woman who has made her life on this, a woman who has been peer reviewed over hundreds of times in different articles on this subject, is willing to throw that all away to come down here at a substantially reduced fee to testify is ludicrous and it's insulting. They pay their experts just the same as we do. Okay. Then that's why I asked their blood spatter expert, his fees. It wasn't acting like there was anything wrong with that. It's just to show both sides hire experts, both sides pay experts. Just because the expert isn't getting paid doesn't mean that they are money grubbing liars. Okay. Experts in this type of thing to come and testify, they charge money, they charge a fee. She actually reduced her normal fee to come down and to help with Ms. Stauch and to do this evaluation. And what did she tell you, ladies and gentlemen? Ms. Stauch, of all the hundreds and hundreds of different mentally ill people that she has ever dealt with, is one of the most mentally ill persons that she's ever dealt with. And what else is she saying? I think this is key. Pay very close attention. She's not endorsing that it was definitely Maria that did this. She's not endorsing how Maria is saying this happened. What is she saying? Ms. Stauch has, in her opinion, more than likely disassociated the memory of the homicide because she can't bear to deal with it. That was actually a very good question by Mr. Young on it. And I think there's a lot of validity to that. Ms. Stauch accepting the idea that she committed this brutal, horrible homicide in the manner that was done, smashing that 11-year-old's head in, cannot deal with it. To accept that fact in her mind would crush her, would crush her soul, would crush her identity. And so she has come up with all of these delusional fantasies, trying to come up with some other thing that may have happened. And listen to her voice, listen to the tenor when she's describing that. When she's hoping, when she's talking to Dr. Lewis, I can't remember if it's Dr. Lewis or Dr. Torres, about the different versions she's given, that she was coming up into her mind, hoping and believing it was somebody other than into his mind, based on what he knew of his half sister, was there had to be some type of psychotic break that had happened. That there could be no other explanation as to why it did it. And those are people that knew her and that have grown up with her. I also want to talk a lot, or some, about Dr. Torres. And it is what is important, ladies and gentlemen, to know with both Dr. Torres, Dr. Gray, and Dr. Grimmett is none of the experts that you have heard from that did any type of evaluation think that there's no mental illness going on here. Okay, they all agree there's some type of mental illness. They just disagree over what to call that mental illness. We have Grimmett and Torres and Gray diagnosing her with borderline personality disorder, which is a significant mental illness, which, as you said, comes from right on the border between full-blown psychosis and a neurosis. Okay, it's the most serious of all the personality disorder, and it's so serious because there are such prominent features of psychosis that go along with it. Psychosis where people hallucinate, psychosis where people become delusional, psychosis where people stop becoming irrational. All of that stuff can come and go in people with borderline personality disorder. And it comes and goes according to DSM-5, according to Dr. Torres, according to Dr. Grimmett, when people with borderline personality disorder start to experience high stress. That is why Dr. Niederhauser was important. It was not because Dr. Niederhauser made any type of diagnosis or anything with that, but she came to Dr. Niederhauser because he was experiencing high stress and high anxiety that was causing her be unable to perform at work. The stress and all of that was mounting. You can look at her Google searches. The Google searches leading up to this. For whatever reason, her stress in life was becoming overwhelming. She felt underappreciated. She felt like running away. She felt like leaving. She felt like this was all too much on her plate, that there was nobody there to help her. And you heard from Dr. Torres about how people with borderline personality disorder feel stress much different than everybody else. Things that would not be normal stressors for all of us can become extremely stressful for somebody with borderline personality disorder. And the other thing that was important that Dr. Torres, we talked about quite a bit, is it is a lot of the same things, the same type of horrible childhood trauma, the type of trauma where you have one parent who is molesting you and another parent who won't do a damn thing about it, that can cause either dissociative identity disorder or borderline personality disorder. They both come from the exact same of environment that Dr. Torres said Ms. Stauch grew up in. That type of environment is what can cause people to have borderline personality disorder, which then under periods of stress and anxiety can become psychotic. And I think one of the other things, and I think is something to look in, and something I want you guys to think about when you go back in that jury room, is something that Dakota Lowry said at the end. We don't know exactly all the intricacies of the trauma, of the abuse that Ms. Stauch suffered. We don't. Some of that she knows about, some of that she's come to remember, some of that is locked away, some of that is hidden by other family members who don't want to admit it. But what did Dakota talk about when he was a kid and after his stepdad has died and his mom had moved on to another abusive alcoholic in the home, and Ms. Stauch would come visit him? What would she do? She would leave him with knives to protect himself from something or someone. And the fact you can draw that Ms. Stauch sometimes as a kid going through that trauma either had to protect herself with some knives or fantasized about having a knife to protect her. And then you have the connection between Gannon being stabbed 18 times with a knife. Some of these things are hidden. Some of these things are hard to look at, but there is that association there between what we can assume was some of the childhood trauma that Ms. Stauch suffered, how she dealt with it, and how this horrible thing happened to Gannon. And I understand that Dr. Torres didn't think she was insane, but you can't discount the fact that Dr. Torres readily admitted borderline personality disorder, can be a serious mental illness. People with borderline personality disorder can suffer psychosis. People with borderline personality can become irrational. People with borderline personality disorder can disassociate things that the whole person cannot deal with. And that disassociation explains all of these crazy cockamamie lies. It is a fantasy on Ms. Stauch to try to explain this horrible action that she cannot rectify in her home with. And whether you call it borderline, whether you call it DID, I think Dr. Lewis is correct. That is not necessarily the important thing. What the important thing is look at the facts overall and realize this must have been some type of psychotic action going on, because normal people, mentally healthy normal people, don't one day go on a hike, take smiling photos, and the next day stab a kid 18 times for no apparent reason. And no matter how much Mr. Young would like her to be antisocial personality disorder, and he would like that because that takes insanity off the table, none of the evaluators ever have diagnosed her with antisocial personality disorder. None of the diagnoses ever have even had the rule out antisocial personality disorder. Antisocial personality personality disorder is something that is always considered at the state hospital, but there are criteria, and she did not meet it. No matter how many times in different ways Mr. Young tried to ask Dr. Torres about it, she was firm and said, no, that is not the diagnosis that we have given her. That's not the diagnosis that Dr. Gray gave her. It's not the diagnosis that Dr. Grimmett gave her, and it's really not the diagnosis that Dr. Lewis gave her. So all the antisocial personality disorder talk is a smokescreen. And when you take the antisocial personality off, the only thing that explains her conduct afterwards is disassociation, is disassociating from the horrible thing that she has done, and she's trying somehow to fix this or to get out of it. The other thing that I want to talk to you, and it's important, that was very apparent with Dr. Torres, Mr. Young would like you to believe that the only time somebody is legal insane if they commit the crime and they just stay there saying, yep, it was me, I did it for these reasons. Dr. Torres and the jury instructions from the court state somebody cannot know right from wrong, but still recognize that their conduct was criminal when it occurred. And so you heard from Dr. Torres, just because somebody in a state of psychosis, in a state of insanity, commits a horrible murder and then tries to cover it up, the covering up of the murder does not preclude insanity. And she talked about how there are cases that she has had where somebody was insane who then tried to cover up the acts that they have done because they didn't want to suffer the criminal repercussions. They are not mutually exclusive. That's not coming from me. That's coming from the instructions that you have from the court. Ladies and gentlemen, you guys have been above and beyond in this. And we are very grateful for the time that you guys have given us, the thought that you guys have put all into this, the sacrifice in your lives that you have made through this long trial. I'm not going to rehash every detail on here. You guys know it. You guys understand it. You guys have heard the experts. You guys can put all this stuff in there together. We are asking you to find her not guilty by reason of insanity. We're not saying set her free. We're not saying let her go. We're not saying don't hold her responsible. We're saying for you to take into account the mental illness that she suffered and send her down to CMHIP, where you see how it is down at CMHIP during those interviews with Dr. Torres, where she's shackled fully, where there's constraints, where it's a locked facility, and that's where Dr. Torres told you if you find her not guilty by reason of insanity, that's where she is going, where there is repercussions, but there is also treatment for the mental illness that she has suffered from her entire life. The other thing that is important, I just want you guys to remember, is the burden of proof. It's not whether you decide, oh, I think that she was psychotic at the time, is have they presented enough evidence before you that you can say, without a doubt, there is no way psychosis was involved here. Have they completely disregarded that? Have they completely wiped it out? And I, ladies and gentlemen, I would put before you with all the different doctors diagnosing with some serious mental health illness, with their witnesses they called diagnosing with a mental illness that has transient periods of psychosis, when psychosis appearing to be the only rational explanation, when no other motive for this horrible thing, with the overkill that was involved here, with the irrational behavior afterwards, even up and through some of these interviews, even up through some of the trial, all of that points to mental illness. And in no way, shape, or form have they disproven that. And it is their burden. And so if you believe that it is possible that this occurred in a state of psychosis, your legal duty, which you have sworn to do, is to find her not guilty by reason of insanity. And that is what we are asking you to do. Thank you.
Council approach, please. All right, ladies and gentlemen, the prosecution does have a right to a rebuttal, and they are going to exercise that right. But you've been sitting there for a while, so what we're going to do is take about a little bit more than a 10-minute recess, give everybody some time to stretch, use the bathroom, those sorts of things. So if I can have everyone back in the jury room at, say, 10 after 12, we should be able to start on at that point. Again, don't discuss the case among yourselves, don't discuss the case with anyone else, and we'll see you at 10 after 12. All right, for the jury, please. I'll be seated. The record should reflect the jury has left the courtroom. Reset.
Will you just turn the screen back to?
Yes, absolutely.
All rise.
You want to